I've got to go.
So I think it's 5:30. Would it be 5:30?
Yes.
If there are people online, hi, it's 5:30. Then we should probably get going. How about some music? I'll turn my chair so I can actually see the screen. So welcome. Thank you for being here, online and in person. We'll start just with a breath. I could use a breath. I don't know what your day has been like, but I could use a breath. So let's just sit for a second. Almighty and everlasting God, increase in us the gifts of faith, hope, and charity, and that we may obtain what you promise, make us love what you command. Through Jesus Christ our Lord, who lives and reigns with you and the Holy Spirit, one God, forever and ever. Amen. So, we always, at Trailside, what we use for the readings looks towards Sunday, right? So we do the readings we're going to do on Sunday. Which means we're actually observing the Feast of St. Andrew tonight, even earlier than we will be on Sunday. The Andrew's feast day is November 30th, and we back it up because it is inconvenient to try to honor St. Andrew and the first Sunday of Advent at the same time. We tried that once, and we'll never do it again because it was awful. But it means now that what is this? The 21st of November, and we're using the readings for St. Andrew, so my apologies for that. But there we go. This is a reading from the Gospel of Matthew. As Jesus walked by the Sea of Galilee, he saw two brothers, Simon, who's called Peter, and Andrew, his brother, casting a net into the sea, for they were fishermen. And he said to them, "Follow me, and I will make you fish for people." Immediately they left their nets and followed him. And he went from there. As he went from there, he saw two other brothers, James, son of Zebedee, and his brother John, in the boat with their father Zebedee, mending their nets. And he called them. Immediately they left the boat and their father and followed him. I shouldn't laugh at that, but I just think that's an astonishing story. I mean, there must have been some backstory, right? I mean, surely these four guys, including Andrew, our patron, had some awareness of who Jesus was. He wasn't just some guy who walked up and follow me and I'll make you a fisher of people. Okay, or as if they were under a spell or something. I don't think it was that. They must have had some understanding. Must have heard the stories. They must have maybe already done a miracle that isn't recorded. I mean, I don't know. Something must have been pretty amazing about Jesus' presence for business guys. I mean, these are commercial fishermen. They made, like, small business owner. They made their living this way. So to think they would just run off, it must have been incredibly compelling. And so Andrew is one of the people here in this story. I've always kind of wondered why for the Feast of St. Andrew we don't hear the story out of John's Gospel about the call of Andrew, because it's kind of much more interesting in some ways than this one. But we'll take John's story and this story together and look further too. Sunday, as you probably know, Bishop Diane will be with us, and she will be preaching. I'm not going to have anything to say about St. Andrew, so this is my shot, I guess, to tell you Andrew's story and why I find him compelling. But if you go back to John's Gospel, Andrew is the first apostle. He's the first one to recognize Jesus' messiahship and go tell somebody about it. So he was originally a follower of John the Baptist, and early on in John's Gospel, John the Baptist points over to Jesus and says, "No, there's behold the Lamb of God. He's the one you should be following, not me." And Andrew takes John at his word and says, "Okay, I'll go follow Jesus instead." Seeing him, recognizing him as the Messiah after spending like an afternoon with him. And what's compelling, I mean, the recognition of Jesus as Messiah is compelling, but also Andrew wants to share that good news, wants to take that encounter and give that life-giving reality to the person he cares about the most in the world, his brother, and Peter. And I just think that's a fabulous model. That would be his first instinct or his first impulse. I've seen the Messiah. I got to go tell my brother because this is so life-changing. I want to share it with somebody and the person I love most. So there's that in John's Gospel. Then there's this story out of Matthew and Mark where, like I say, there's this also kind of an immediate recognition on Andrew's part and the other guys too in this story, but an immediate recognition, Jesus is the Messiah. We need to find out more. I mean, this is a whole nother question. I wonder if these guys following Jesus understood that they were completely starting their lives over. I mean, how much did they know? How much of what was coming did they have a sense of? Or was it just, we got to find out more? Even if it's just that, we got to find out more. That's pretty compelling too. But they go. They leave the nets behind and leave Zebedee behind. There's a whole other story that you could play out. What about Zebedee? Like, wait a minute. I've lost everything here. Anyway, so they follow him. Next in the gospel stories, you fast forward to not quite the time of Jesus' crucifixion, but close to it in John's Gospel. In John's Gospel, that is signaled by people from other nations, the Greeks, like non-Jews, coming to the movement. They're catching on. They're seeing the life-changing experience that Jesus is offering, and they're saying, we want to see Jesus. And they come to Andrew. And Andrew, this is another moment of decision, right? Andrew could have said, you're a Greek. Go away. Go do your Greek things. We're Jews and we don't associate with you. But he takes the Greeks to Jesus, and Jesus takes it as a sign of, okay, now the story is moving this way. This whole universal salvation thing, now we're seeing it play out. So that's an important Andrew moment too. Before that is the one maybe he's most famous for. Is it in Matthew? I think it's in either Matthew's or Mark's, can't remember, account of the feeding of the 5,000, right? So Jesus is there, and there's this crowd, and he's teaching, and everything's great, and the disciples are looking at their figurative watches and saying, it's getting late. You probably ought to send these people away because we don't have anything for them. Thousands of people, what are we going to feed them for dinner? And Jesus says, you give them something to eat. Which is another one of those laugh lines in the gospel we don't laugh at enough, I don't think. But it's a great line. You take care of it. And they're like, how do I? Got to be kidding. We don't have any money at all, much less what it would take to buy food for these people. And Jesus says, okay, go see what you can find. And it's Andrew who comes to Jesus with the 5 loaves and the 2 fish. There's this kid here who has 5 loaves and 2 fish. What do you think about that? And Jesus does what it is another laugh line, that's right. And Jesus does what he does. He takes this incredibly meager presence of blessing and turns it into more than anybody could ever imagine. So Andrew he's not Peter, right? His brother outshines him in the story, but he has these moments of really important points in the gospel story. So then, outside the Bible, tradition says, of course, the tradition says all the apostles went different places, and that's how the world got evangelized eventually. Okay. Well, Andrew is said to have gone at least 3 sort of different directions that might have been mutually exclusive, so you don't really know which one's precisely true, but there's a strain that says he went to Ethiopia and brought the good news there. There's a strain of the story that says he went to Ukraine and Romania and Russia, what areas now. And in fact, Andrew is the patron saint of Russia, and I think of Ukraine too. So there's a clear association in the Russian Orthodox Church of Andrew as the primary apostle to them, the one from kind of their Peter. You know, the Roman Catholic Church builds on Peter, well, the Russian Orthodox Church builds on Andrew as the founder or the primary apostle. Then maybe the most believable, I don't know, strain of the story is that he went to Greece, evangelizing there, and was martyred in Greece. The story being on an X-shaped cross. So you see X-shaped crosses in our worship space. That's what that's about. You know, that he was crucified on a cross like this, not like this. And then the story gets even stranger. The tradition is that a monk, unidentified monk as far as I know, somebody is said to have taken his remains from Greece and transported them to Scotland, of all places, which explains why he's also the patron saint of Scotland, and explains why there is such a place as St. Andrews, where people like to go play golf now. But before people liked to go play golf there, it was a center for learning and mission and evangelization of Scotland and northern England and all that. So Andrew has left his mark there too. And it's that connection through the Scottish church that makes Andrew the light for the Episcopal Church. You think about the Episcopal shield and it has this X-shaped cross on it. That's why, because we're remembering the Episcopal Church's historical link to the church in Scotland and its identification with Andrew. Anyway, there are lots of things you could do with that long story, but I for some reason I was finding myself focusing on Andrew as kind of the patron saint of enough, you know, which I think is something we need. There's the sense as he meets Jesus, all he needs is the encounter with Jesus. That's enough to stake his life on it. And it's enough simply to have had that experience to go and trust it's going to be compelling enough with this person you love most in the world, with your brother, to bring that person along with you too. You know, he didn't need data. He didn't need, experiments and lots of encounters. He just had a life-changing experience and figured that'd be enough to share. So I like that sense of enough. There's also, of course, the enough of him going out into the world as an evangelist with no training. This guy's a fisherman, right? He doesn't know what he's doing. He's never, presumably, been to Ethiopia or Greece or Russia or wherever he went, but he trusted it was going to be enough. The Holy Spirit was going to equip him to go and do this, and that his encounter with Jesus was powerful enough. It was going to be convicting. And I think that's powerful. And then there's, of course, the feeding of the 5,000, the ultimate example of enough. All we have, and we do this here too, right? All we have is this loaf of bread and this cup of wine, or the little cups of wine on the tables. All there were 5 loaves and 2 fish, and out of this experience, like feeding the 5,000, out of this experience, Jesus comes to be present with us in nothing more than some bread and some wine. Just very basic material, And Andrew helps bring about this sense of, if you have some, you have enough. And if you have enough, you have me, Jesus says. And I just think in a world where everything around us tells us you need more, right? What you have isn't enough. You got to go get more. You got to earn more. You got to buy more. You got to whatever more. It's all about more, right? So the world tells us that. The world also tells us you're not enough. So be afraid. So, So strive for acquisition. Recognize that you don't really have any power. There are all kinds of things that flow from you're not enough. But it's just the opposite. We've been made in the image and likeness of God. That's enough. We're the ultimate enough. We're the ultimate sacramental presence in the world. You could look at it that way. And I just think Andrew opens that door for us. I think it's a great, he's sort of an unplumbed resource for the church. We don't pay as much attention to Andrew as we should. So we'll get to pay attention to him on Sunday. We'll get to blow bagpipes and bang drums and do all kinds of fun stuff. So we won't have bagpipes and drums now, but I do think we have music. Is that right? Unless you have bagpipes and drums there that I didn't see back in the closet.
No bagpipes, but I do have a guitar. So. Where you
So what are we bringing tonight? What do you have on your heart and mind to pray about tonight? Maybe start with the wide circle, and we'll narrow it as we go. What in terms of the world, the community, the world around you? What are you praying for tonight? And you can, if you would, use the mic there so people at home can hear.
You don't think my 4-kid mouth will be enough?
It's on, Beck. Just talk into it.
Today I was a woman whose mother had passed away at a young age, and she was grieving. And all she needed was to talk for just a couple minutes. And I asked her what her mother's name was. She said, Brenda. And she said, will you pray for her? Sure. So I raise up to you all, pray for Brenda.
For Brenda. There you go. Lord, in your mercy, hear our prayer. Thank you. What else?
I'd like to pray for the two 18-year-old teenagers that were killed last weekend by a runaway driver going down the wrong way of I-29.
Yes.
Hit 'em head on.
Yes, that's right. Thank you. Lord, in your mercy, hear our prayer.
I think during the last weekend too, there were 2 officer-involved shootings. An infant was killed as a result, and then there was a boy that was killed as well. Both of those were mental health / domestic incidents. So pray for both the parent and the kids that were shot by the police officers.
Yes, indeed. Lord, in your mercy, hear our prayer. Yeah, Charlie?
We've been praying at home for about a month. As we have been in the election, we read a lot of news, watch politics.
Yeah.
It's been the most divisive period that I can remember in my life. Although I've studied enough history, it's not the first time this has happened. So we've been praying that God will watch over our communities and make wise decisions focused on the broader interests of the community rather than more focused, selfish interests.
Hear, hear. Lord, in your mercy, hear our prayer.
For those that are going to be out in the cold this
Yes.
winter, it is like last week it was really, really warm, and this week it's just immediately chilly.
Yeah.
And it's only going to get colder, so just prayers for those who don't have anywhere to go.
Absolutely. Lord, in your mercy, hear our prayer. How about people you know, family, friends, that sort of thing, or needs, concerns for yourself? It's absolutely right and good to pray for yourself.
I guess I'll give it a go. Prayers for safe travels down to Springfield for Thanksgiving. It's not a very long drive, but anything can happen.
There you
so
go.
just
Yeah.
prayers for safe travels.
Safe travels. And for all those millions who will be traveling. Lord, in your mercy, hear our prayer. What else? Yeah, Brenda?
Prayers for my neighbor Willa, who's going to have a pacemaker tomorrow.
Oh, really?
Yes, 6:45. Yes,
And very early, too.
yes, very. Yeah.
Okay.
Anyway.
Indeed. So, Lord, in your mercy, hear our prayer.
And pray for Brenda's sister, who's recovering from an automobile accident.
Oh, really? Oh, my goodness. Lord, in your mercy, hear our prayer.
I have one more. Prayers for Ward Cook.
Yes.
He just underwent hip surgery, so
Yep.
prayers for him, and for healing for Ward Cook. Ward
Recovery
Cook
after
just
hip
had
surgery.
hip surgery. Yeah. I'll guess I'll find out on Sunday, but I should.
No, it was yeah, it went well. Yep.
Well, prayers for healing for Ward.
Lord, in your mercy, hear our prayer. That's fabulous. Well, let's gather all that in the prayer Jesus taught us. Our Father, who art in heaven, hallowed be thy name. Thy kingdom come, thy will be done, on earth as it is in heaven. Give us this day our daily bread, forgive us our trespasses, as we forgive those who trespass against us. And lead us not into temptation, but deliver us from evil. For thine is the kingdom, and the power, and the glory, forever and ever. Amen. So as we remember Jesus and bring him into our presence, his presence into our presence, let's remember just how powerful enough can be. The Lord be with you. Lift up your hearts. Let us give thanks to the Lord our God. It is right and good to thank God for all the blessings that fill our lives, and especially for the gift of Jesus, God with us. On the night before he died for us, Jesus took bread and broke it and said to his friends, "This is my body, broken for you. Do this for the remembrance of me." Then he took the cup, and small cups on the table, for that matter, and said, "This is my blood of the new covenant, given for you. Whenever you drink it, do this for the remembrance of me." Gratefully, then, we remember that Jesus lived for us and died for us and rose for us again. So, Lord, through your Holy Spirit, be present in these gifts of bread and wine, that they may give us strength and courage to do the work you call us to do. In your holy name we pray. Amen. Alleluia. Christ our Passover is sacrificed for us. Therefore let us keep the feast. Alleluia. So these are God's gifts for you, for God's beloved people. Just serve yourself. Well, we don't have the little plates for the bread. I'll bring the bread around. Serve yourselves from the cups there on the tables. And if anyone would like gluten-free wafer, we have that as well. Well, yeah, let's do. Sorry, I forgot to get the little plates out. So they will be coming here in just a moment. It's okay. It's okay. There we go. Thank you very much. And I'll come to you. almost time for dinner. Time to say thank you and say grace. God of all, thank you for sharing yourself with us in the bread and wine of eternal life. And thank you for the meal you're now setting before us. Bless the hands that have prepared it, and bless us to be strengthened for your work in the world. In Christ's name we pray. Amen. Let us bless the Lord.
We are not that. You get the post message.
Well, I have 6:30, so we'll get started. I have kind of intervened here. Sarah was going to introduce Gretchen, but I kind of got Gretchen into this and felt obligated to do so. So I'm going to do it. She has a vast. I've known her for 18 years now, and we practiced law at the same law firm at Lathrop GPM for that long, and completely different subjects, but nonetheless, I've known her, I think, incredibly highly of her. She's very accomplished. She practices estate planning in all aspects and permutations of it. And I can say that she's very skilled because she's done my estate plan. And so I think that she's very well qualified to talk about what she's put together here that's in the material and answer any questions you may have. In addition, if, say, at any time, if you want to talk about something other than estate planning, I recommend you bring up the subject of fishing. Gretchen is an accomplished fisherwoman. And she goes up to Canada every year and brings in the big lunkers of walleye and pike and such as that. So if nothing else, you can always ask about fishing, and she'll tell you a fish story. So I think very, very highly of her, and I've gotten her here to help you all and to answer any questions you may have. And I know I was just talking to her today. She keeps up on all this stuff, being estate law and planning to the minute, because she was telling me about a new Missouri statute that has generated some business for her estate planners in our firm. And I'm not going to go into explaining what it is. She can, but in other words, she knows everything up to date. And I'm happy to introduce Gretchen Gold.
Oh, I have to put this on. Yeah. Forgot the most important piece. Okay. All right, now can you hear me? Okay, okay. Do that. See if we can get back to my screen. Okay, so there's a lot of materials in the handouts that I'm not necessarily going to talk about. I'm not going to just regurgitate every page. First of all, I understand that you either have had or are planning to have another speaker on powers of attorney. Is that right? Yeah. So I'm not going to talk about powers of attorney, although there are some slides in here on those. I'm going to touch on a few things, and then we'll just zip past a few pages because I want to focus on what I think is the most important piece of this. Part of it is what Steve said, this new statute that we have in Missouri that just became effective in August. And assuming most of you, because you're come to St. Andrews, you may be Missouri residents. We still do the same type of planning for Kansas residents. It just doesn't have the added feature that I'm going to talk about, but we still use the same techniques. Steve said I do a great job on estate planning. Unfortunately, he doesn't know how good I do until he dies. But anyway, that's when the real test comes. To just add a little bit to what he said, I've done nothing but estate planning since I got out of law school. I really wanted to be a litigator, so I went into commercial litigation, but the firm I was with rotated new attorneys for the first year. And once I got to the estate planning group with Elvin Knight, I was never able to get out of it. And part of the reason is because I'm willing to do estate and trust litigation, and most estate planners don't ever want to step foot in courtroom. But that has given me a very unique perspective on planning, and I can spot issues that someone that's never done the litigation side of it may miss over. Very little litigation is over poorly drafted documents. It's more over something in the family dynamic that wasn't taken into consideration. And feel free to raise your hand anywhere in the discussion. You don't have to save your questions to the end. I'd rather get them covered while we're talking about the relevant topic. So, how many people in this room think they have an estate plan already? Okay. No, I'm going to tell those few people that didn't raise their hand, they do have an estate plan, they just don't know what it is. But I'm going to help you understand why. So why do we do estate planning? Obviously, everybody's going to die. They don't have a cure for it yet, but it's far more than estate taxes. Making sure that you, yourself, your spouse, your children have financial security after a death in the family, planning for health and financial decision-making while you're alive but incapacitated. That was last week's discussion. Avoiding probate at the time of death, which is something us lawyers like. Probate is not necessarily a bad thing. It just takes time, and you have to engage an attorney. And if you're going to pay us up front to do trust planning, why do you want to pay us at the tail end or have your heirs pay us at the tail end to do the probate also when we can easily avoid it? And it is very time-consuming. And it's also subject to court supervision and public information. We can address estate taxes, obviously. Asset protection, that leads into what I'm going to talk about in Missouri. Controlling inheritance to your children or grandchildren, and charitable giving. So those are pretty much the basic reasons that people come to see us. So basic techniques, there's intestate succession. For those that did not raise your hand, that's what we call it when you die without a will. And whatever the statutes in the state where you die say, that's what your estate plan is. And it's not always what people think it is. We use wills when appropriate. We use trusts. Sometimes we will use joint property or beneficiary designations. And then we used advanced planning when there's either specific charitable intentions or special needs planning or that kind of thing that come into play. And most of the estate plans that we plan have some aspect of wills, trusts, and joint beneficiary and beneficiary designations. So it's a mix of techniques. So I'm not going to go into this in a lot of detail, but if you die in Missouri without a will, everything does not go to your spouse. If you die in Kansas and you don't have a will, everything does not necessarily go to your spouse. That's a misnomer.
Can you drop the left-hand side of the screen so that the main screen be larger?
Adam, do you know how I can do that? Or somebody? Because I was looking for an X to do that, and unfortunately, I'm not sure where it is on here. Yeah, these slides are all in your book.
There you go.
There you go.
Thank you.
Okay, perfect. Okay, so in Missouri, the first $20,000 goes to your spouse plus half. The other half, if you have children, goes to the children. If the children are not from the spouse that you're married to at the time of death, the $20,000 goes away. Beyond that, we go to nieces, nephews, siblings, grandparents, that kind of thing, out to 9 degrees of relationship if you don't have descendants. Stepchildren do not inherit, and in Missouri, adopted children only inherit from their adoptive parents. You say, why did she say that? Well, in Kansas, that's different. I'm going to skip over this because that gets us to the 9 degrees. In Kansas, they have what's called an elective share. Again, you cannot disinherit your spouse. That is the only person you cannot disinherit under the law without their consent. So if you have no children, everything goes to the spouse. But if you have children, half goes to the spouse, the other half goes to the children. Again, stepchildren do not inherit. But uniquely in Kansas, adopted children inherit from under intestate law from both their adoptive parents and their natural parent. So we always ask, have you given up children for adoption? Do you have any legally adopted children? Because that's something you want to know. Now, when you do planning with us, we can draft around this, but for those that don't have a will, I'm just telling you what your estate plan is. And then again, Kansas will go out several degrees. If you do attempt to disinherit your spouse, there are elective shares. In Missouri, it's basically 1/3 of the estate that you can take from the probate. In Kansas, it depends on how long you're married. You start at 3%, and after 15 years of marriage, it goes up to 50%. And in Kansas, it includes property that you might have beneficiary designations on, things like that. In Missouri, they cannot take those assets. So very different laws in both states if you die without an estate plan that you have sat down with an attorney to plan. So hopefully I've convinced those handful of you without estate plans to go see a lawyer already. Wills are the primary technique. Now, I get comments all the time, I have a will, I'm not going to be subject to probate or estate tax, right? A will has nothing to do with probate or estate tax. In fact, if you have a will-based plan, you are guaranteed to have a probate estate because wills are worthless pieces of paper until you die and until they are submitted to the probate court and an estate is opened. They do nothing during your lifetime. As I said, wills are public record. Once they're filed with the court, anybody can either go online or walk into the courthouse and pull them. If we have a probate estate, they can pull the inventory, they can see what your assets are, they can see who you leave them to. If it's a spouse who's incapacitated or a minor children, obviously that's not something you necessarily want the public to know, but it is public record. And also, if you have minor children or a disabled dependent, a will is the only place that you can designate a guardian for that person. So those are the most important reasons that people have wills, is for the guardianships, to avoid the guardianships. Wills can do everything that trusts can, set up trusts at your death, direct, controlled inheritance to children or beneficiaries, things like that. But again, all of that is in the court where anybody can go in and look at what the assets are and who you leave them to. Probate is a legal process, as I said. You have to have a court action open. It does take time to have a probate estate. In Missouri and Kansas, it typically takes a year. If we have a large estate where there's going to be estate tax, it can take several years. We've had estates that stay open 5 and 6 years because of issues that are there. I'm not saying we can necessarily administer those faster under a trust plan, but at least it's not all in the court, and we don't have to go petition the court and get court orders for everything that we want to do, and it's not all subject to public scrutiny. We have to give notice to creditors, actual notice, and publish notice to creditors, and we have to give those creditors a reasonable period of time to come to court. So that's the first delay, is you have to hold the estate open for a period of time for the creditors to come in and file claims. Beyond that, then it's usually just a matter of, are we having to sell assets because you've got 5 children in one house and, all 5 kids don't want the house, or estate tax returns and things like that. But probate is very easy to avoid, and so we just like to avoid it at all costs. Here I've got some reasons on why. And if you own property, real estate in multiple states, there's a chance we're probably going to have to probate in each one of those states. That causes a further delay. So if you've got a vacation home in Colorado, that kind of thing, it can delay things again if you have a will-based plan. So trust. This is what we like. I would encourage everybody to have a trust, but so the grantor of the trust is the person who creates it. There's some different lingo we use in the trust world. There has to be a trustee. During your lifetime, you can be your own trustee. You lose no control over the assets. You can do anything with assets in the trust that you can do with assets out the trust. You don't have to report to anybody. You don't have to account to anybody. They are still your assets. It is literally just a title change during your lifetime. You don't even have to file a separate tax return for the trust. The trust will use your Social Security number, and everything will be reported on your personal return. If you become incapacitated, you get to designate who the person is that steps in behind you to manage assets for you while you're alive. So you want to be very careful in who you choose as the trustee. And then once you pass away, the trustee is the person who holds the assets for the beneficiaries. So the requirements of a trust are a creator of a trust, a trustee of the trust, assets, and beneficiaries of the trust. That's all the only legal requirements for a valid trust. So let's talk about Missouri a little bit. So Missouri is now, and has been, but is now a very creditor protective state. Okay, and by that I mean not we're protecting the creditors, we're asset protection from creditors. So Missouri has for a long time had what's called a self-settled spendthrift trust. I can take some of my own assets and I can put them into a Missouri spendthrift trust, and as long as I am not the trustee of that trust, those assets are protected from my creditors. Now that assumes that I don't have creditors coming after me at the time I fund the trust. But what we do for a lot of wealthy clients, or like in 2008 when the market crashed, we had a lot of clients that were in their main business, but then they had their fingers in lots of deals with other people, and those other people were going belly up and they didn't want to be taken down with them. No claims had been filed, no lawsuits, nothing like that. So it was not unusual in 2008 for us to create these trusts and put some of the clean assets into the trust to protect them in case those other creditors came after our client who just owned a little piece of the bad deals, and they were left holding the hook. Those trusts hold up in court as long as you play by the rules. We had many of them attacked after 2008, and they have all withstood attack. So now you can't, like I said, you can't put all your assets in the trust as long as you leave enough out for your daily living. So, you know, a lot of people have investment accounts and investment assets that are really kind of for the future. Those are perfect assets that might go in there. Most states don't have a spendthrift trust, self-settled spendthrift trust. Missouri is also a little unique because we are what's called a tenancy by the entirety state. Kansas is a joint tenancy state. Now the difference is they both have rights of survivorship. So for those that are married that own their house jointly with their spouse, your deed probably says Bill and Sally, husband and wife, or Bill and Sally, a married couple, or Bill and Sally, joint tenants. It might say tenants by the entirety. In Missouri, it doesn't matter which one of those you have, as long as it does not say as tenants in common. The default in Missouri for all married couples, any jointly titled assets, real estate or not, is tenants by the entirety. The unique feature of that is that if I'm out driving a car and I cause an accident and I get sued beyond my policy limits and I don't have an umbrella policy and they want to sue me, okay, for the injuries or death or whatever it is, in Missouri, any asset that I have that is joint with my spouse is off the table. Any creditor of mine cannot get to it. It takes a creditor of both my husband and I, the same creditor, the same judgment, in order to get to joint assets. In Kansas, which is a joint tenancy state, same thing. If I was a Kansas resident, I caused an accident, they sued me, they can get to half of the joint assets, subject to whatever the state exemptions are. So the state has certain assets that are exempt. But that's a huge thing. And so prior to 2012, this is when all this kind of changed. Prior to 2012, the federal estate tax laws did not allow a surviving spouse to save the unused estate tax exemption of the deceased spouse. And so what we were forced to do, and the exemptions were much lower then, so what we were forced to do when clients came to us for planning for estate tax purposes was we had to sever assets. We would have a Bill trust and a Sally trust. And so we would sit down with them and we'd say, okay, well, we're going to take the vacation house that you jointly own and we're going to put it in Bill's trust. And we're going to take the personal residence that you own jointly and we're going to put it in Sally's trust. And we're going to take that joint investment account and we're going to put it here or there. But we would have to literally go through the assets and determine which trust we were going to put them in. And we didn't know who was going to die first. And so when the exemption was $1 million, $2 million, $3 million, a lot of people, their insurance policy put them over the estate tax, was going to make them subject to estate tax. So we would have to hedge our bets and try to fund both of those trusts to the extent possible to make sure that we used either party's exemption regardless of who died first. And then on an ongoing basis, we had to work with those clients to make sure that as they acquired additional assets or as some assets grew in value that we equalized it with the other trust. But because we had two trusts, we had to sever the joint tenancy. That always caused us issue, especially when the client is a doctor, an engineer, someone like that that is a lawyer who's worried about personal liability. So in 2012, the federal law changed. The exemption jumped up, first of all, so we have a lot more room to play with, a lot fewer people subject to estate tax. But also what the government said is, okay, if Gretchen dies first and she doesn't use her $5 million of exemption because either I didn't have that amount of assets or I left everything to my spouse, because there's no tax when you leave it to a spouse. They changed the law to say, well, my husband can say, okay, well, she didn't use her exemption, I'm going to save it, and I'm going to add it to mine. It's called portability. There is a return you have to file to elect portability, but it was worth it. And so now in my scenario, let's have my husband die first. I would have his $5 million exemption, and then I would have my own. And as the years went by and the exemptions increased, his would stay at the $5 million because he's deceased. Mine would continue to escalate. But when I died, I could add the two together to cover my estate when I gave it to my children or grandchildren or whatever it is when the tax might be triggered. So that became very important to us, okay? What portability also did was we started moving away from these separate trusts because we no longer had to hedge our bets on who's going to die first and monitor the Bill and Sally trust to make sure that each party's trust had enough to use their exemptions. We could put it all in one trust, a joint trust. So Missouri attorneys, and I was involved, I still am involved at the bar level, we became a little concerned about, okay, we take a joint asset that's tenancy by the entirety, and now we're moving it into a joint trust. Is it still treated from a creditor standpoint as tenancy by the entirety? In 2012, the legislature passed a statute that said yes. As long as a husband and wife put property into the joint trust and it was tenancy by the entirety before it went in the trust, it will remain tenancy by the entirety protection from creditors after it goes into the trust. So we started moving some clients out of the separate trust into the joint trust. The only problem under the old law, the original law, was assets had to be jointly titled before they went in the trust. So we would take individual assets, put them in joint ownership, move them in the trust. The other problem is after the first spouse dies, under the original law, the surviving spouse is no longer married, and so the tenancy by the entirety protection went away. You needed to be married. Those are married couple are the only ones that get the benefit of tenancy by the entirety. So the first amendment we made a few years after 12 was to say you didn't have to go through this hoop of retitling things jointly before you put them in the trust. They said any assets that go into a joint trust will be considered tenancy by the entirety. That saved us some paperwork, but it didn't solve the problem at the tail end. So what I guess I can move on here. So what we did just last year was with the creditor rights bar, which is the bankruptcy bar, and with the bankers bar's approval, the statute was changed so that any assets that come into a joint trust, even if they aren't joint before you put them in the trust, if they go into the joint trust, they are protected as tenancy by the entirety property. They have to be in the trust the moment before the first spouse dies. They will remain protected by tenancy by the entirety after the first spouse's death, even though the surviving spouse is no longer married. That was a huge change. If the spouse remarries, they can set up a new trust with a new husband, and these are still protected. So this created a great creditor protection opportunity for us. That was kind of a problem for us, was what do we do after the first spouse's death? Now we no longer have to deal with it. To my knowledge, there's not another state that has this type of joint trust statute. There are other states that have great asset protection trust and laws on the books, but most of them involve you setting up an irrevocable trust and essentially giving your assets away. Missouri statutes between the spendthrift trust and the qualified spousal trust, you do not have to give your assets away to get that protection. So it's huge. So if you have, those that raised your hands, if you have separate trusts with your spouse, it's probably worth making a phone call if you're concerned about creditor liability, and especially for the surviving spouse after the first death. It might be worth talking to him about converting to a joint trust and getting those protections in place. So we no longer have to sever those assets and all of that. Beneficiary designations, transfer on death, pay on death designations are still a little troublesome for us because remember I said the assets have to be in the trust the moment before the first spouse dies. So if the first spouse has assets that say upon my death the beneficiary is the trust, those are coming in the moment after death. So those wouldn't be protected, but we can have them go into the trust and have them treated as being in a separate share so we don't taint the other assets. But if you are meeting with the lawyers and they say you really need to change the ownership of the asset, this is one of the reasons why. Other than retirement accounts, there are no assets that we cannot retitle in the name of the trust. We may have to jump through some hoops and things like that if it's a business interest and stuff, but there really aren't any other assets beside qualified retirement assets that we cannot retitle. So to the extent we can, we want clients to get those into the trust. The surviving spouse can still have the trust that she or he ends up with can still be completely revocable by them. There doesn't have to be an irrevocable share, anything like that, which is great. It used to be we used irrevocable shares to get that treatment. As I said, if they get remarried, they can set up a new trust. Titling has to be done right. And if you've ever met with a lawyer on estate planning, we give you lots of instructions on this is what we want you to do. I can't tell you how many estates. There's, thousands of dollars worth of estate planning documents that the family brings into me, but the client never did the homework and got the assets retitled. So we end up probating those assets. It is even more important now under this new statute that you get those assets retitled. Most of the time the lawyer will prepare the deeds for you if you're dealing with real estate. But the other, we can't change your bank accounts. We can't change the beneficiary on your retirement accounts. But we will give you very specific instructions on how to do that. And I urge you to follow through and not just think, oh, I'll get to it later. That is the most important step to getting this protection as well as avoiding probate. Contrary to what you might hear at a cocktail party, all of the estate planning we do, no matter what we do with titling of assets, unless there is a premarital agreement or a postmarital agreement, has no impact on division of assets at death. Okay? Marital and joint property concepts for divorce are completely different than what we deal with in estate planning. We also do premaritals and postmaritals, but it's usually done with this kind of thing in mind. And the really neat thing about these joint trusts, because a lot of my clients are on a second marriage, is we can take separate assets under a premarital agreement where, I've said, these are my assets, you don't have any rights to them. I can put those assets into the joint trust, keep them in a separate share that I control, and they get the protection of that tenancy by the entirety. So it's a really, really unique statute. And like I said, no other state has it. You have to be a Missouri resident to qualify, but I'm assuming that most of you are. I think I've encouraged Steve to move to Missouri, by the way. Okay.
Microphone.
On the page before about the Missouri Qualified Trust, at your last bullet point is beneficiary transfer on death and payment on death designations do not work. I presume it means in these qualified spousal trusts.
They work to get the assets in the trust, but assets, because they would be coming in the moment after death or sometime after the first spouse dies, they don't get the tenancy by the entirety protection if they go into a revocable share. Now, if they come in the trust and they go into an irrevocable share that the spouse can't control, then they are still protected because they're not the spouses, but they're not treated as tenancy by the entirety property.
What does a party in this position do with these types of clauses that are kind of, well, I think they're oftentimes put out by banks and investment companies where you're designating where you want upon your death, where it's supposed to go. Could there be a conflict between those provisions and the trust?
Yes, so when a client comes in to do estate planning, we ask for a list of assets. And so I will know if you have an account at Schwab or Fidelity or whatever it happens to be. And so then when we meet to sign the documents, I will say, Steve, you need to get with your Schwab guy and you need to change the ownership of this account to the joint trust. And that works. That gives you the tenancy by the entirety protection. Like I said earlier, the only asset we can't do that with is a retirement account. So we have to do the beneficiary designation. Now, retirement accounts are a little unique. If you have named your spouse, whether it's in a trust or outright, your spouse gets to stretch it out over their lifetime. And as long as the money stays in the retirement plan, it's protected from creditors under federal law. Okay? So that's not the issue. But if we have a child, for example, that's getting the account, it's not going to be tenancy by the entirety anyway. They have different rules that apply, but again, we can put it in trust to give them that protection or not. But that's why I say we give very specific instructions we want you to follow up with. If you, after you've met with me a year or two later, you have some event that you have assets and you want to open a new account, this is where we run into problems because you meet with your broker and he says, oh, well, we'll just name your trust as beneficiary. If I find out about it, I will say, Steve, it'd be better if you just retitled it in the name of the trust so you get this protection. I would then go to the broker. If the broker has a problem with it, we talk it through and we try to come up with the best solution. If you really want the protections after it goes into the trust under a beneficiary designation, then we're going to suggest it go into an irrevocable share because that will get the creditor protection as well. Any other questions before I move on? So as I said, trusts are our favorite form of estate planning. They're completely revocable as long as you have capacity. If you don't have capacity, those powers of attorney you learned about last week, you can give your agent the power to modify a trust. They cannot modify a will. So again, if you have a will-based plan, it's going to be set in stone if you become incapacitated. With a trust plan, your agent, who presumably you trust, can continue to modify that trust as long as it's consistent with your estate plan at the time that you passed away. Changing assets to a joint trust for creditor protection isn't going to violate any plan. If everything's set to go to the spouse and then the kids, we just need to make sure that we keep that kind of a general plan in place. You get to choose who's in charge. If you die without an estate plan, the court or the first person to that courthouse that applies to be your trustee or your personal representative is most likely to get appointed. You get to choose who makes decisions, who chooses your nursing home, or as I say, you get to choose who doesn't pick your nursing home. Who gets to control the unplug you and all of those kinds of things. Trusts are completely revocable, completely private. And the best thing compared to probate is if you do have a surviving spouse or minor children, assets in a trust are immediately available. We can start making distributions to support those family members right away. If it's running through a probate estate, depending on the situation, we have to get the estate open. Sometimes that takes several weeks. We have to have a death certificate. We have to have all kinds of information to get that open. But then depending on what's going on in the estate, the court may not let us make distributions for a period of time. And so that can cause a hardship on your family members. Disadvantage, if you don't have many assets, it can be cumbersome, but again, now with the new creditor protection, that's becoming less of a reason not to do a trust. It does cost to hire us to set up a plan. Obviously, we have nothing but our time to sell, but I will tell you that setting up, paying $4,000 to $6,000 with me or any other attorney, that's kind of the going rate for a spousal combined plan these days. is a whole lot less than probate. I can barely get through the first month of probate for less than that. And that's using a paralegal. It's just that cumbersome to do a probate estate and the inventories and all of that. So you're better off with the money at the front end rather than at the tail end. Other techniques that we use to avoid probate: joint tenancy with rights of survivorship, pay on death, transfer on death, those kinds of things. And we always ask about life insurance, retirement plans, other real estate interests, oil and gas interests, things like that, to make sure that we've captured everything. And a lot of people don't realize it, but life insurance doesn't do you much good during your life, right? It pays off when you're dead. But it is taxable. So if you do have a taxable estate, unless we've planned to get that insurance out of your estate, those assets are also subject to a 40% tax. Now, I'm not going to spend a lot of time on tax, but I'll touch on it in a minute. Most of the people in this room, I'm guessing, are not going to be subject to estate tax. Also, any charitable gifts that you make are not subject to tax. Okay, so if you give money to the church or the hospital or something like that, it's not going to be taxed. What is in your estate? Doesn't matter whether it's a probate estate or a trust estate. Estate is a generic term that we use. It includes any bank accounts, even if you're just a co-owner or put on there for convenience. Investments, retirement accounts, life insurance, your home, digital assets. This is one that gets a lot of people off guard. You know, when you have those credit cards that give you perks, those perks are available to your heirs. Those are assets. And so we need to make sure that we deal with those assets. Refunds, frequent flyer miles, those kinds of things. And whether it's a trust or whether it's an estate, we have to deal with creditors and debts. Now, this is another thing people don't always understand. If we have a probate estate and we open the estate with the probate court, we must, by law, publish notice in an obscure legal newspaper that says, Steve died, Gretchen was appointed as personal representative, all creditors are notified to file claims within 6 months or you're forever barred. Okay? We are also required to give actual notice. I must send a letter to every one of Steve's creditors, whether it's a credit card company or whoever it is, to let them know the same thing that the publication has. So all actual known creditors have to get actual notice. If you don't do that, they have up to a year to come in and file a claim. And that notice, believe it or not, there are, like the banks and the hospitals will come, and Medicare, Medicaid, they comb through those notices to see if there's, and run the numbers through whatever database they have. In a trust estate, if we don't have probate, there is no requirement that we give actual or published notice to any creditors. It doesn't mean that we don't in some circumstances, but as a general rule, if somebody walks in and all they have are a couple of credit cards and maybe a final medical bill, we're not publishing notice, okay? We're not sending actual notice out. They're going to know you're not alive when you don't make the next payment, and that's usually how we discover them. But we can play a little game with those creditors that we, you know, because of the notice, doesn't work as well as probate. But if a creditor contacts me and says, well, I'm calling you as the, you know, attorney for Steve as trustee of this trust for whoever passed away, if they haven't filed a probate claim, because we didn't open a probate estate, I don't have to pay them out of the trust. Unless the trustee of the trust signed on the debt, I don't have to pay them. And I can just say we don't have a probate estate. Now, if they are smart enough, they will force open a probate estate to file their claim, perfect their claim in probate, and then present it to the trustee, and then we would pay it. But we're not going to tell them how to do that. Now, it sounds bad, I know. I hope nobody's with banks or hospitals here. But I can't tell you how many final medical expenses and unsecured loans that have just been written off the books because they didn't do that. And it doesn't take that long to file a claim, open an estate, perfect it, and file it, especially if it's a several $100,000 claim. Secured creditors we can't get rid of. They always have their security interest in the asset. But using a trust rather than a probate allows us to make the creditor jump through some hoops before they get paid, and most of them will not do it. So that's just more for your heirs. Something else, just because I said heirs right now. Heirs and beneficiaries are different. You do not have heirs until you die, or you don't have identifiable heirs until you die. Your heirs are those people under those intestate laws that are entitled to your property, and so we don't know who those people are till you die. And they are not necessarily descendants. They might be relatives out to the 9th degree. Your beneficiaries are who you designate in a will, a trust, or under a beneficiary designation to receive your property. And a lot of times people are like, well, she's my heir. Well, we don't know that until you're dead. So just cocktail conversation there you can use. I'm not going to talk about durable powers, but reasons to plan your estate. So this kind of brings us full circle, but we have financial security for your spouse and descendants. A lot of times people say, my spouse has never balanced a checkbook, doesn't pay the bills, I do it all. If I pass away first, you know, the utilities will be turned off. I don't even know if she knows where we have bank accounts. So you can put somebody else in place to assist her, whether it's a child or a bank or a trust company. But you can set that up so that you're comfortable with who's managing the assets and that they're going to take care of the people that you want them to. So we have a lot of dysfunctional children, and they're not always young. And so you can control the inheritance to them. And I have had clients do silly things like get, you know, $500,000 and decide they're going to quit their job, go to Vegas, and become the next World Series of Poker champion. I believe they were back in less than 6 weeks, penniless, and begging their siblings for some of the money that the siblings got. I can't stop that unless you do planning and put it in a trust or in a form that they can't take it all and go to Vegas. I've seen all kinds of other silly behavior among people. So that's a big reason these days, is to control it. You can also do your children a favor. I call it giving them their cake and eat it too. Just like tenancy by the entirety offers creditor protection. If you leave assets in a trust for your child, they don't own them. They can be the trustee. They don't own those assets. Their creditors can't get to it. So clients of ours that have children that are in the medical field or engineering or other high-risk fields, they will frequently say, well, my child has more assets than I do. Okay, well, you're doing them a favor if you put these assets in a trust. They can be in charge of it, but then you know that if they get sued for liability on their personal assets, they've got this as a nest egg. It also prevents the assets in the trust that you leave them from being subject to division if they get divorced, where their assets would be on the table, the assets you've left them in a trust or not. Special needs planning. If you have a special needs child, assets in the trust don't have to be spent down for their care before they qualify for public assistance, where if you give it to them outright, they would have to be spent down on that care, or Medicaid could come back and recover from them at the time of their death. So there's lots of reasons. Estate tax also, if you give, in my example of a child who's very successful on his own, they may have an estate tax issue of their own. Why compound it by giving them more assets that are subject to tax? You can set up education trusts for grandchildren while you're alive and gift it into that, knowing that they're not going to go to college for years. It can be what I call a pot trust for multiple grandchildren, or separate trusts for different children. If you want to start making gifts to children for other reasons, you can do that. And you can also disinherit anybody except your spouse, up to those spousal limits, unless they consent. Now, if they've signed a prenup or a postnup, they can sign away their right to inherit, but the spouse is the only one. So if your children, you ever hear them say, well, I'm entitled to this. No, they're not entitled to anything. In fact, Steve's probably heard me say this too many times. The best estate plan is to bounce the check to the funeral home, because that means you've enjoyed your retirement. I tell my children all the time that's what's going to happen. Again, asset protection for you, asset protection for the next generation. In cases of second marriages, where there are children from one or both of those marriages, estate planning is very important. Because otherwise, for example, my husband's 8 years older than I am. He has 2 children. If he dies first, which I tell him he statistically is going to do, and all the assets come to me, he either has to trust me that I'm going to include his children, or you have to set up an estate plan that guarantees that at my passing, his children are going to get something or be treated equally with my children, if that's the plan, which in our case is. Spendthrift planning. We have what we call trust babies. Those beneficiaries who have trusts set up that just spend money like it's going out of style. It's not unusual on some Monday mornings for us to get a call saying, I was arrested over the weekend, I need you to send a check to, let's say, Charlie Horner so he can get me out of jail, you know. Depending on how the trust is written, the trustee may have no alternative but to do that. If it's a well-written trust, it would be optional on the part of the trustee, but the beneficiary couldn't just go out and buy a Lamborghini and then tell the dealership, call the trustee because he'll pay for it, okay? So we do a lot of that kind of planning. I said special needs. Motivation trusts. So if you have a child who has failed to launch, I'm not saying anybody in this room has those children, but you can set up a trust where they're given an incentive. So we will match your earned income on this basis, dollar for dollar or 50 cents on the dollar, to encourage them to go out and get a job. If you have a child who is a teacher who unfortunately isn't going to make much money, right? You can add special provisions to supplement their income, things like that. So there's lots of other reasons, and charitable planning, of course, that we do estate planning other than just estate tax. Special needs planning we do not just like somebody on the autism spectrum, that kind of stuff, but also for substance abuse. If you have a child that has a history of substance abuse, you can set up a trust that makes sure that they're not going to be able to just take money out to further that problem, that, you know, the trustee can pay for rehabilitation and they have to be clean for a certain amount of time before they're entitled to distributions, things like that. As I said, you can deal with a beneficiary's creditors. And this last one, you can choose your own nursing home instead of letting your children decide. And I have honestly had, I mean, I've seen it all in doing this. I've honestly seen children fight over whether mom should go to, name the nicest nursing home you know, versus the worst, because that's my inheritance you're spending, and she has Alzheimer's. She doesn't know the difference between the nursing homes. I don't think I want that child picking my nursing home. You know, I've touched on, I think, most of these. Oh, business succession planning. If you have a business and you have, this is very common for us, you have 2 children. One got involved in the business, one didn't. You want to treat them equally. We can deal with that in an estate plan, where if you give the stock 50% to both of them, you're going to have someone who wants to liquidate that interest interfering with the management of the company. And so we can deal with those kinds of issues in the estate plan. I will tell you, fair is not equal and equal is not fair. I don't care where you end up on the spectrum, but you need to make sure your estate planning attorney knows where you do so you can adjust it. There's something to be said about, on the surface, treating your children equally so you don't have bad feelings between them, but that's not always what people want. And I hear, after mom and dad are dead, I can't tell you how many times I've heard, this isn't fair, because when you were 16, you got the new car. I got the hand-me-down. This isn't fair because they paid for you to go to Northwestern and I just went to JUCO, so I should get some money off the top to equalize that. I hear things from 40, 50 years earlier that they just hold on to, and it's just sad. It's very sad. Estate taxes. I know you're all anxious in this. The current exemption is $13,610,000 per person. So if you have less than $13 million, don't worry about estate tax. For husbands and wives, that's double. Okay, that's over $27 million now. Next January 1, it goes up to $13,990,000. On January 1 of 2026, right now, It's going to go back to $5 million, but indexed for inflation since 2012. That will put us at roughly $7 million, so $14 million a couple. We believe that's going to go away. We believe that will be eliminated, and that we will go back to the $13,990,000 indexed for whatever it gets indexed for in 2026. But we'll have to wait until the new administration takes office and see how things goes. But that's what we expect. If you do have a taxable estate, the tax is 40% of any assets over these amounts, and the tax is due 9 months from the date of death. We can get an extension to file the return, but not an extension to pay the tax, which means that if all of your assets are tied up in a business, for example, we don't have the cash available, so your estate planner will help you plan to have cash available. Otherwise, we have to have a fire sale and come up with that money somehow, because the IRS does not wait for its money. This is just more of what I just... Missouri and Kansas do not have a state inheritance tax anymore, so there is no state tax. The other thing people don't quite understand, this is on the income tax side, under current law, when you die, any assets that you own get a stepped-up basis for income tax purposes. So if I bought Apple stock at $10 a share, and I hold it until I die and it's worth, $10,000 a share when I die, my children will inherit it at the $10,000 a share basis. So if they sell it the day after I die, there is no capital gain. If I sold that stock the day before I die, all that capital gains comes due, okay? So there's a big benefit. That's the other thing we do, is we try to plan for that stepped-up basis. In the joint trust, it's really neat because we can get a double step-up. We get a step-up at the first death in the deceased spouse's assets, and we get another step-up at the second death in the surviving spouse's assets, which frequently include the assets that got a step-up at the first death, okay? There is no other income tax that's paid at death. You don't pay tax on insurance proceeds unless you go over the $13 million. You don't pay tax on insurance proceeds. You don't pay tax on inherited assets. If the asset incurred or earned interest or dividends after the date of death, you will pay income tax on that post-death earnings, but not on the capital gain that went away at the time of death, or just the inheritance of the asset itself. Mm-hmm. Yes. Yes, that's a federal statute. So the 13,610,000, I know that change is bothering some of you, but the $13 million number is a lifetime number and at death. So any gifts you make during lifetime, as long as they do not exceed this year $18,000 and next year $19,000, you're not using any of your $13 million. If you give a gift of $20,000, then you're using $2,000 of your $13 million, because the first 18 is covered by the annual gift. Spouses, it's double. That's for a single person. So if you're married, you can give, $36,000 to each child's spouse, each grandchild, whatever it happens to be. We do a lot of that because as you get more grandchildren and so forth, you can reduce somebody's estate pretty significantly. And we frequently will make those gifts into a trust rather than giving it to a minor or, a young, irresponsible child. And by that I mean in their 20s or 30s, where they're not going to do what you want with it. The other thing, and this is kind of something some of you may be interested in, is you can make two types of gifts, and it doesn't come off your exemption or your annual gift, and that are medical payments and tuition payments. The trick is you must pay the provider directly. So if my son is, has some unexpected health issue, and he goes to the hospital and he's got a huge copay, okay, or uncovered expenses, if I write the check to St. Luke's, it's not a gift to my son. But if I write the check to my son to pay that bill, I've made a gift that I have to worry about these limits on. Medical expenses are very broad. It can be yoga classes, it can be therapy, it can be prescriptions from CVS, it can be paying Blue Cross premiums, it can be paying a hospital or a doctor, physical therapy, wheelchairs, motor scooters, any type of medical expense. As long as you pay the provider directly, it is not a gift to the person that you're then paying that for. On the education, it is tuition only. They don't cover room and board, and they don't cover books or miscellaneous fees. But if you've got a grandchild that's going to school and the parents really can't afford it and you don't want them to have to take out student loans, write the check directly to the education institution for the tuition. And it can be Montessori school, it can be private lower school, it can be private high school, it can be college. It doesn't just have to be college, where when you do those 529 plans that some of you may be familiar with, that's for higher education, okay? It doesn't help you with the lower school. But pay those things directly to the institution or the provider, and you don't have to count it as a gift or report it on a gift tax return. I'm about done. I think this is my second to last slide. We also do advanced planning. Insurance trusts, irrevocable trusts, so that would be where we might put that insurance to keep it out of your estate. If you're making gifts to minor children, we'll use an irrevocable trust, those kinds of things. Qualified personal residence trusts, there's a technique that right now the interest rates are favorable for. You would take your house, put it in, or one vacation home you can use, put it in a trust, you retain the right to live in that house for a period of time. At the end of that period of time, the legal ownership passes to your children at a very low tax cost, a fraction of what its fair market value is. You have to rent the house back from them. That's the downside. But you've removed that house from your estate and given it to the children or whoever at a lower tax cost. We use a lot of family partnerships and limited liability companies. We put assets in there because if I give Steve 50% of a piece of real estate, it's the value of the real estate. If I put that into an LLC or a partnership and I give him a 50% ownership interest, if I keep or I don't give him the management rights, I can discount the value of that interest, sometimes 30%. Okay. So we use a lot of those. It also helps us in the situation I said where you've got 2 or 3 children and one's active in the business or the farm and the others aren't. It's a way that we achieve the equality without disrupting the actual running of the business. Grantor retained annuity trust. This is another one that right now works pretty well. You put assets into the trust. You get an annuity back every year that for however long it works, and then you keep it, and then at the end of the trust, the rest of it goes to your children, including the growth and appreciation at a much reduced tax cost. And then charitable planning. Obviously, you can write a check directly to St. Andrews, and he would be glad to take that check. Other techniques are to set up charitable foundations, use donor advised fund, use various charitable trusts where the charity gets the lead interest and the remainder at a period of time goes to your family or vice versa, where the family gets the lead interest and then at the end the remainder goes to charity. But those are all advanced techniques that we get into. Here are some other ones. If you are inclined to make current charitable donations, if you haven't heard about it, I encourage you to talk to your retirement plan administrators about making qualified charitable distributions. You're all familiar with required minimum distributions. If you direct Schwab to take your required minimum distribution, either all or part of it, up to $100,000, but if you say, I want you to take $50,000 of my RMD for this year and give it to St. Andrews, they will write the check directly to St. Andrews. You get the other $50,000 if your distribution's $100,000, but you only pay tax on the part you get. The part that goes directly to the charity is tax-free, where if you take the $100,000 and then you write a check to St. Andrews, you've got to report and pay the tax on the full $100,000. So that's it's now part of the permanent law. So it's a great way to make current charitable donations and reduce the tax liability on your retirement distributions. Pledge agreements. We do work with a lot of charities on these. These other ones I've mentioned. If you have low basis assets that you don't want to hold until you die when you get that step up, those are fantastic assets to think about giving to charity. We're in the process right now of giving a condominium in Florida to a charity that has about $900,000 worth of capital gain in it. We're going to transfer it to the charity. We know, and the charity knows, they're not going to keep it. They're not going to be in the rental business in Florida. They're going to turn around and sell it. Assuming they get $1 million, $1.2 million for it, whatever it's worth, that's all. The donor doesn't have to pay that capital gain. All that money goes to the charity. So there's lots of different ways that we can achieve your charitable objectives. I don't know where I am on time. I think I'm doing okay.
Go back to the,
Okay. I was going to open it up for questions. I don't have any more slides, so.
go back to the place where the parents rent their house to the
Children?
children.
No, you rent it from them. Right.
Yes.
So I take my house and I put it in a trust and I say I'm going to live in my house for 10 years. So I retain a 10-year interest. The kids can't sell it out from under me. I don't have to pay anybody anything. It's same business as usual. But I know in 10 years I'm going to want to downsize, move to Arizona, something like that, right? So I put the house in the trust. I retain a 10-year term. At the end of the 10 years, if I do want to stay in that house, I just pay fair rental value to my kids for that house. If I don't want to stay in the house, the legal title passes to the kids anyway, but the trust prevents them from selling it out from under me if I want to live there. But at the end of the 10 years, if I'm ready to move on, the kids can sell it and the money's theirs, or I leave it in trust. I can control where it goes. But I've for gift tax purposes, it's not the value 10 years later that I'm giving the children. It's the value on the date I set up the trust less my 10-year retained interest. And so I can significantly reduce the value of the gift. So we can give, a $5 million house to kids at $1 million tax cost sometimes. Now, the thing is, we don't want to set the term of the trust so long that we think you're going to die during the term. So, if somebody is sick or really elderly, you want to keep that term shorter in the hopes that they survive the term that they get to live in the house. But it's a great technique, and right now the interest rates work really well. You have to, when we're valuing the gift, we have to use a federal interest rate that's set each month. And right now the interest rates just make those trusts, as well as these annuity trusts, these grantor retained annuity trusts. It's the same concept, just without a house. You put money in there and you get an annuity back each year, but at the end of the term, the rest of the assets with the growth and appreciation go to your kids. So it's a great technique to get assets out of your estate.
I will try and make this succinct. Assume that my husband's father died in Missouri with a will, and of course this is not based on true facts.
You're asking for a friend of a friend of a friend.
Yes. Died in Missouri with a will, very modest estate, modest home, some personal property, sentimental value, and about 3 pieces of dilapidated property with house structures on them, garages that he's purchased over time that are ready to fall down. Sister is made executor. It's now been 6 or 7 years, has never probated the will. It's just gone on like nothing has happened. My husband wants nothing. He wants to disavow or disclaim anything that he might get under that will, because all it's going to cause is heartache and problems. Can he do that in advance of the will being probated, or must he wait for the will to be brought to probate and then file something?
So, first of all, your sister messed up by not filing the will if she didn't file it. Now, if she preserved
It's
it,
my husband's sister,
okay.
just to be clear.
In these made-up facts.
Yes.
So, unless the will was filed within 1 year of your father-in-law's death, he basically now has died without an estate plan. And so we've got to look at state law. We cannot file the will more than 1 year after he dies.
So now he's considered dying intestate.
Correct. Okay. It is too late for your husband to disclaim his interest. A disclaimer must be done within 9 months of your father-in-law's death. That's not to say your husband can't disclaim it now, but it's not a qualified disclaimer, so he's going to be treated as receiving his 1/2 or 1/3 or whatever of those assets and then giving them back to the others. So a qualified disclaimer allows you not to be treated as though you never received the asset. But because he didn't disclaim in time, he's going to be treated as receiving it and giving it to whoever it goes to because he doesn't want it. So he can disclaim it, but there may be tax consequences to it. Gift tax consequences or use of exemption. So your sister-in-law, if the assets pass under the will different than they do under intestacy, she's got personal liability to those people that were named in the will that aren't going to take. Okay, so she's got a whole list of issues that aren't your problem or your husband's problem. I would encourage to do something. You should not really just bury your head in the sand, because after your sister-in-law and your husband are gone, there's still those properties out there that are in your father-in-law's name. At some point, somebody has to deal with those. And they're either going to be foreclosed on by the city or the county for failure to pay taxes, upkeep them, that kind of thing. They're going to be, you've all heard of this title lock insurance. There's not much of that going on, but these dilapidated properties are the ones that are being targeted for someone to come in and steal the title. I mean, there's a whole host of liability issues, but we get these kind of calls all the time and say, my great-grandmother died living on the farm, but there was never a probate estate. Everybody just went on farming the property and everything. And now my brothers died, my sisters died, I've got nieces and nephews, and all of a sudden we have to go in and we have to go to court and basically do an intestate estate for every one of those generations that didn't do what they were supposed to do at the time. So it's much easier to do while your husband and his sister are alive, but it's going to be a hassle.
Okay.
And if she didn't file the will, your husband can go to court and open the estate. She would have to then come in and say, I was named in the will, and have the court say, well, you didn't file the will, so guess what? And that's a reason in and of itself not for us not to appoint you.
Thank you.
I know it's not the answer you wanted.
What do you do about jewelry and fine art?
Okay, so those are the biggest fights we have over personal property. And if you've gone to any estate sales recently, you will see a lot of really nice tchotchkes and stuff. This next generation doesn't want stuff. They are minimalists, and so that stuff is going for cheap or ending up in the thrift stores. I encourage people to let their children go through while they're alive and kind of, let me know, make a list of what in a perfect world you would want, and then you can decide based on what they want. You can make a list of specific items, sign it and date it. You don't have to call me to amend your documents, and as long as you signed it and date it, and we know it's a list of personal property at your death, those people will get it. You can change that anytime you want. In terms of fine art and jewelry, we will get those appraised. If we don't have an estate tax return, it's much easier. We need a different type of appraisal for estate tax returns, but assuming you're not over the 13 million, we get those appraised. And if one child wants the, $100,000 painting, then either the other children get $100,000, or assuming that's what the document says, is that they're all treated equally, or we put the painting up for auction, and if you want it, buy it. But we, on the expensive items, we try to equalize those, so we do need values at the time of death. If you've designated it to somebody, then they're going to get it regardless of what the value is. But the personal property is what we get the biggest fights on. Don't use yellow stickies. They can be easily switched. They can be thrown away.
My
I have
mother-in-law
had,
did that.
yes. And it's the first person in the house that gets to decide, no, Sissy's not going to get that item.
Well, also make sure everything is notarized if you make a list.
It doesn't have to be, but that's a good idea. I
Well-
tell people to give it to me because then I have it in the file. And if they find your copy and destroy it and go, Mom didn't make a list, I go, that's funny because
Well,
I've got one right here.
We had one from Kansas that was with the lawyer and with us but it wasn't notarized and they wouldn't accept it.
A personal property list by law doesn't have to be notarized, but a lot of times you get, well, Mom promised me this. Well, Mom promised me that. Well, Mom gave that to me while she was alive, but I just let her hang on to it. Okay, without documentary proof, we don't do that. I've had house cleaners when they heard that their person passed away at the hospital go in and help themselves to stuff. We've had paintings missing off the wall. We've had garage doors, opened, things like that. So I tell people, make sure that, somebody knows where you have hidden your keys, where you hid the Cougarans, things like that, so that we can collect all that and get in there as quick as possible. I've had to hire armed off-duty policemen to monitor children going into the house because they didn't trust each other. Well, she's going to steal Mom's jewelry. She's going to,
The state of Missouri does not tax individual pieces of jewelry. It
No.
does in Illinois, and I would,
Illinois has an inheritance tax,
and I
yes.
had to remove all jewelry before she died.
Yeah, Illinois is one of a handful of states that still have an inheritance
Please don't
tax.
hit.
So an estate tax is a tax on the estate of the deceased. An inheritance tax is a tax on the recipient of the property. And so some states still have inheritance tax, and it usually depends on the relationship. Spouses don't pay inheritance tax, but once you go to children, grandchildren, each generation, the rate of tax is a little bit higher. So moving out of Illinois or moving assets out of Illinois was probably a good piece of advice.
I had a philosophical question on a similar topic. We had our estate plan in 1999, so we worked with our kids at least once a year. But my children tell me that as they talk with their other friends, none of them have had their parents say one word about their estates. I'm just interested in what you do in counseling clients on how to develop relationships with your children, explaining your estate plan while you're doing things. Doesn't that avoid a lot of troubles?
It does. So certainly the larger the estate is, I encourage them to, it's not when the kids are like in their 20s, right? But as they get older, I encourage them to sit down. Usually I'm involved in that, and I will come up with a one-page diagram of the flow chart of the estate. You probably have a flow chart in your notebook from Scott. And that's what we will use. I won't put numbers to it, so they won't know if you have 26 million or, 200,000. I just explain to them how it's going to flow, and if it's going to go into a trust. Why did we put it in trust? Now, the most comical such meeting was with a husband-wife with 3 children. One was a doctor at Children's Mercy doing high-risk neonatal surgeries, worried about creditors, and had great income of his own. The other one would be perfectly happy living in the back seat of his car with his Kmart purchased blue jeans. He didn't care about material things. He was a chef, and he just wanted to be creative in the kitchen. But he didn't pay his own bills. His parents were still paying his bills for him. He just had no interest in it and was not into material things. The other one lived in LA. And, well, let's just say he had developed a different taste. And he lived well beyond his means. And he was known to go to Mom and say, can you give me $1,000 because I need some new clothes this month? And, okay, but don't tell your dad. I'm supposed to be weaning you off, right? So then he'd go to Dad and say, can you give me $1,000 to buy something this month? Okay, but don't tell your mother because we're supposed to be weaning you off. And, of course, Mom and Dad talk and find out he's manipulated him, right? He is a spendthrift. He is the perfect example of a spendthrift. So they asked me to sit down with the 3 kids. So I had my little diagram, and we went through it. And I explained these trusts that all the assets would go into and the benefits of the trust, just like I went through with you. And the doctor said, oh, my God, that's such a relief, because I'm always worried about malpractice, and, it's going to compound my own estate tax problem and just put a bigger target on my back. Now I don't have to worry about it with inherited assets. The kid who lived in the backseat of his car, and he literally did at one point live in the backseat of his car, he said, you mean I can just call the bank and say, would you pay my rent this month would you send a check to whoever for my car repairs? Yes, you can do that. Oh my God, that's wonderful, you know? Then we had the third child who was not happy with mom and dad. What do you mean the bank's going to be in charge? And I have to ask them,